What's up? What's up? What's up? It is the Bad Wolf, and we're going to be talking a little bit about an attorney in fact and what a power of attorney is and what their capabilities are. Why do we even need to know any of that? Well, a lot of people have heard me mention that I'm an attorney in fact. An attorney in fact can really be pretty much anybody who has a decent understanding of the law, procedures, and they're operating in the private. You do not have to be licensed to be an attorney in fact. Now, one of the things is that operating as attorney in fact, you're basically handling things because the word attorn means to turn over. And in fact means that you operate in facts, which a lot of the courts don't like. Facts are real world. They operate in illusion and subterfuge, legal fictions, dead entities. So the moment you mention that you're an attorney in fact, they'll know that you are versed well enough to handle yourself. Do not try to use that title to scare them. If you don't know what you're doing or what you're talking about, don't use the title. If you're going to represent or, excuse me, represent yourself, remember, living people are in the present. So I will be present. If you represent, you're saying that you are the dead fiction, or you're operating essentially as it. That's why I say you are going to represent yourself. No, I'm not going to represent myself. I'm going to present myself. So when you tell them or you what you're doing, they may say, well, so you're going pro se. Pro se means pro and se together is a short for prosecutor. Pro se, pro se, pro se, pro se, prosecutor. You're saying that, hey, hold me to the same level as a normal prosecutor, though I'm pretty sure I don't know how to do everything properly. You want to go as yourself in the present as sui juris. Okay. Now, let's take a look at what they got going on here.
Attorney in fact versus power of attorney explained.
Shot goes out to attorneyhelp.org. This is we're going to call this fair use. It's already on the internet. And we're just sharing the information.
Explained. Image source, Unsplash. An essential part of estate planning is making legal decisions surrounding real estate, finances, and healthcare. Ideally, you would be present and prepared to perform these tasks yourself. However, there may be times when incapacity or long-term travel could hinder your ability to make these decisions. In these instances, a power of attorney and an attorney in fact could be beneficial to take care of your estate and finances. This guide will define an attorney in fact versus power of attorney and how they work. What is an attorney in fact? When creating a document for power of attorney, the person named is the agent, also known as the attorney in fact. The attorney in fact makes decisions on behalf of the principal. An attorney in fact's range of power and responsibility depends on the specifications indicated by the power of attorney document. Sometimes, the court could assign an attorney in fact if a person becomes incapacitated. An attorney in fact may get one of two kinds of powers of attorney. General. The general POA allows the attorney in fact to sign documents, conduct business, and make decisions on behalf of the principal. Limited. The limited or special power of attorney is similar to a general POA but can only apply in specific situations.
Most times people will give or utilize a limited one, power of attorney. You're basically saying that you're giving somebody the power to turn over things in your name on your behalf, whether competent or incompetent, incapacitated. And attorney in fact just means that they are the person turning it over. So the POA is the document that makes it personalized to you. The attorney in fact is the person doing it. Some people, you can do a POA, power of attorney, with a regular attorney, a regular lawyer, or anybody else. So that's general. You can just basically, hey, I want you to be, I'm going to give you power of attorney over my estate, my financial affairs, my whatever, limited, 1 month, 1 week, 1 hour, one event, the rest of my life. But be careful when doing that for the time limit. You don't put a time limit on there or specifically mention from this to this date, or an emergency, it's this person. You you literally have given them the same power that you have, which means they could sell your stuff, they can sign contracts and do all the things that they want to do in your name unless you're very specific. You can give this to a regular person, you can give this to an attorney in fact, give it to a lawyer, an attorney, somebody at the bank. So be careful.
Situations. While the terms sound the same, an attorney in fact is not necessarily an attorney at law, also known as a lawyer. An attorney in fact does not need special qualifications or licenses, although they can also be lawyers. Attorneys at law could represent you in court or give legal advice. An attorney in fact is not required to do these things. What is a power of attorney? A power of attorney, POA, gives an agent legal authority to make decisions on a principal's behalf. If you grant someone a POA, their choices would be as legally binding as the ones you make yourself. This legal document could be broad or limited, depending on the powers you choose to delegate. It is often useful when settling affairs concerning one's estate, finances, and medical care. Two main types of powers of attorney cover healthcare and financial affairs. Healthcare power of attorney. A healthcare power of attorney, HCPOA, allows your agent to make decisions surrounding your medical condition, care, and treatment. This document often applies when you can no longer communicate your decisions due to incapacitation. You must be able to trust your agent or healthcare proxy. They might need to make life or death healthcare decisions. Assign a spouse, close friend, or family member for this type of POA.
Like I said, be very careful. Okay. You can also do here a financial power of attorney. Okay.
POA. Financial power of attorney. A financial POA. There are three. A general power of attorney can grant. The third type of financial POA is a durable power of attorney. Under this arrangement, the agent has the authority to manage financial matters until the document's revocation or the principal's death. However, how to assign someone power of attorney?
Okay. So you can go. We can go into those. Not really needed, but let's keep going.
Attorney. Before setting up a power of attorney, ensure you are familiar with your state's laws. Different states often have specific formats and guidelines you need to follow. Next, choose your agent.
Mind you, this is also doing it in the United States under their guidance to ensure that everything that's done and said is properly executable and enforceable. So you must dot your I's and cross your T's for your state. If you're doing a completely private one, you still want to make sure that you do it really well, get it notarized, be careful, check all your dates and times and Make sure that the person that you're signing this over is somebody solid as AF. Because you will be held to this. Now, if you do it completely private, you should be safe as long as you do everything right. But if you have a disagreement about it, you're going to have to bring that matter to the public, and then they're going to look over it, and they may say that the whole thing was not enforceable. This violates your constitutional rights. Or they may say, yep, this stands. Okay, so either way, just be careful when you do this.
Your agent. Ideally, this is someone you trust to handle financial or healthcare matters in your best interest. They could be a business partner, a spouse, a close friend, or a family member.
I ain't got no, I ain't got nobody that I would trust with. Now, obviously, I might have to turn it over at some point in time, another 1,000 years from now. Um, but yeah, you really want to be sure who you do this for, whether it's when you get senile or in case an accident might happen, because whoever you turn it over to, they're going to have to do what you have put in there to do, or you're going to give them enough power that they could F you over. So be careful. Cannot stress this enough. If you do this or when, be careful. I've seen where some people did this, they weren't healthy, turned it over, everything over their estate and whatever else to this person, got healthy, and couldn't get their own stuff back.
Member. Below are standard guidelines on how to assign someone power of attorney. Write down the agreement. Use precise language to avoid confusion. Use the proper format. Make sure to choose a state-approved power of attorney form. Assign the parties. The principal grants the POA while the agent receives it. Identify the powers that you, the principal, want to grant. You could be as general or as specific as you wish. Specify the POA's durability. How long will the POA last? Will it terminate if you become incapacitated? Notarize the POA. Many states require you to sign the POA in the presence of a notary public, but not all. However, notarized signatures could help the agent assert their authority even when it isn't required. Record and file it with the appropriate public office. Some states do not require this step, but it can help establish the existence and validity of the document. Planning ahead. Creating a power of attorney is an excellent way to plan, especially surrounding financial and medical matters. It helps you maintain control even if you cannot make legal decisions yourself. However, it is critical to choose an attorney in fact that you trust. They have a fiduciary duty to act in your best interests. Think thoroughly about the powers you choose to delegate and whether your agent can faithfully carry out these tasks.
Now, if they don't do what you have described in there, that would be breach of the agreement or breach of trust, and you can go after them for that. But it can be very daunting to try to get your stuff back or money or whatever property once it is gone. So be careful with whom you give that to. Most of the time, I'm going to tell you right now, I'm not giving it up. I'm not built like that. But what I would do is upon, me reaching the age of, 1,732, um, and I decided to leave the earth, then, I might consider then letting them pry it from my hands, that power and control. But in most cases, it's good to label, you could even label like a bank power of attorney to handle out your trust or make the bank a trustee. You know, um, that's why a lot of people, when they do their in United States domestic trusts, they register it with the county or, the whatever, the courts, so that they can administer over your estate. But by you doing it with the will or whatever else, then they will follow those things. If not, they will say, well, he left all of this U.S. citizen property in his name, which is a resident or resident of ours. We will do it. And what do they do first? They pay all your bills. And then if they're crooked, those same companies double dip behind you, and that's not cool. So if you don't want all of your stuff, first thing my dad said before he passed away is take all the money and run. Don't pay any of my bills. Why? Because he knows at the end of the day, they're just going to get discharged. He doesn't care about his name and social being dirtied up and using the exemption on it. Take the money and run. You guys do what you guys need to do, and I'll talk to you guys later. Don't forget to hit that bell, like, subscribe on the way out. Peace.